Good morning and welcome to the Committee on the Revision of the Penal Code. We're going to take a few seconds here to have our um, audience room populate. It takes a little while, a couple minutes for us to get started, and then we'll get rolling. Thank you for joining us. All right. Good morning and welcome to this meeting on the Committee of the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair. I want to put a little asterisk by today. It's Yom Kippur. I'm obviously not celebrating, and those who are probably aren't with us today, but I just wanted to mention that and apologies to those who couldn't join us. So let's begin with a roll call of committee members in alphabetical order. Assemblymember Bryan, I do not see him. Hopefully he will join later. Judge Espinoza,
Here.
Mary Kennedy,
Here.
Professor Ochin cannot join us, Professor Rummel,
I'm here.
and Senator Weiner cannot join us. All right, we have a quorum. We're ready to go. Here's our agenda for today. We'll begin with a staff presentation about our main topic, which is victims' rights and the issue of serious and violent felonies, or the issue of the definition of serious and violent felonies. Then we'll have a presentation from our colleagues at the California Policy Lab on serious and violent felonies. And after that, we'll have two additional presentations. One from District Attorney Dan Dow, who I believe is the president of the District Attorneys Association now, and Tanish Hollins of Californians for Safety and Justice, both about victims' rights and priorities. We'll then have a panel discussion about victim needs, and we'll get the panel discussion. After that, we'll get brief updates from staff about our legislative program this year and recent crime statistics. And finally, we'll discuss ideas presented today and conclude by deciding which staff proposals should be included in our report at the end of the year. So that's kind of the important piece programmatically, at least for committee members today, is that we will be voting on which concepts or which ideas / recommendations will go into our final report. As always, we will have subsequent time later in the year to edit and refine those points, but we just want to make sure that we have the general ideas moving forward. Make sense? We'll of course take a few breaks along the way, including lunch around 12:30. All right, I just have to read this Bagley-Keene announcement. Let me remind you that we are governed by the Bagley-Keene Open Meeting Act. Please note that members of the public can watch and participate in this meeting at the first floor conference room at 925 L Street in Sacramento. Thank you, Megan, once again for being present at that location. Second, a reminder to committee members that the law requires that members of the committee, quote, visibly appear on camera, unquote, during the meeting unless there are technical difficulties or a screen is being shared. If you do have technical difficulties along the way, please let us know and we can try to handle it from there. Okay, with that said, today we are covering victim rights and the question of how California defines serious and violent felonies. This committee has returned frequently to victims' rights and needs, and I'm eager to continue this study, particularly because of the ongoing funding issues that service providers for victim services are currently experiencing. We are also going to examine the Penal Code's list of serious and violent felonies, which can often make sentencing harsher and have many other consequences. The expansion of these lists, since they were first created in 1977 and 1982, have been justified as protecting crime victims, but survey of crime victim survivors show that many prefer support services and recovery assistance over harsher punishments. The Penal Code can do much more to provide those services, and I believe there is room for rationalizing the serious and violent felony lists by removing some crimes that I think most people would think are neither serious nor violent, and adding some offenses that I think we all agree are serious and violent. With that said, I'd like to get started. We'll begin with a staff presentation and to set the stage for our issues today. Rick and Tom, can you take it from here?
Great, let's do it. I assume everyone can see the slides. Okay, so we're going to talk first a little bit about the serious and violent felony list, how they came to be, what their original purpose was, and what has happened since then, and also include some staff recommendations for adjusting those lists, as Mike suggested. And then Rick will talk a little bit about the victims' rights and services piece before we really turn our attention to that. So let's start with the violent list. So the violent list was enacted as part of the determinate sentencing law in 1976, effective in 1977, and originally had 9 categories of offenses, and now it has 25 categories. So it has expanded dramatically since then. The original intent the legislature had in creating this list was to identify extraordinary crimes of violence against the person. This is just how the list grew. This is the original list from 1977, and then here it is today. It was most recently added to last year, actually, after a period of not being adjusted for a while. So that's the violent list, and the reason the legislature created it as part of the determinate sentencing law was to create a 3-year sentencing enhancement, where if your current offense was violent and you had a prior violent offense, you could get a 3-year enhancement. So that was the original purpose of that list. The serious list came a few years later in 1982, created by a voter initiative, Prop 8, which also created the first Victim Bill of Rights in California. That list originally had 26 categories. It now has 44, most recently added to a few years ago. The serious list, the California Supreme Court said the list was not devised with precision. There are many overlapping categories. You can qualify as serious. One offense can qualify as serious under multiple categories. The categories, many of them didn't map neatly onto existing offenses. So it's created a lot of court decisions, let's say, about exactly what counts as serious. And the serious list was created by Prop 8 for a few things, but mainly for the nickel prior, which was also created by Prop 8, which was a 5-year sentencing enhancement that was available if you had a current serious offense and a prior serious offense. So essentially that 3-year enhancement became a 5-year enhancement and applied in a lot more situations. So those were the original consequences, were these sort of recidivist sentencing enhancements in 1977 and 1982. That really became a lot harsher with the 3 strikes law in 1994, which, as we all know, required doubling a felony sentence if you had a prior strike offense, which is a serious or violent felony. And then originally the law required a 25 to life sentence if you had 2 prior serious or violent felonies, regardless of what the current felony was for. Of course, that was changed in 2012 with Prop 36. And realignment also created a pretty serious consequence for a serious or violent conviction. It required a mandatory prison sentence for an offense that otherwise required a jail sentence. So, realignment made a lot of incarceratory sentences be served in county jail, but not if you had a serious or violent or a PC 290 offense. And there are many, many more consequences. We laid out in the staff memo dozens of consequences that are specific to serious and violent convictions that happen automatically if an offense is added to one of these lists. And we also have the whole history of the additions to the list in the memo as well, if you really want to get into the nitty gritty. But I think the most important consequence is almost one that doesn't happen, which is adding something to the serious and violent list doesn't by itself increase the sentence length for that offense. You'd have to adjust the underlying triad or other prescribed sentence for it. Adding it to these lists increases punishment only if the person has a prior serious or violent felony as well. So I think that's something that sometimes gets lost in this discussion. Obviously, anyone feel free to interrupt me as we get going here.
The only piece that I wanted to add is, of course, the nickel priors or the 3-year priors for violent crimes. First of all, there's a little bit of mismatch there. You get a 3-year hit if extra added to your sentence for a prior violent offense, but a 5-year added to your sentence if you have a prior serious offense. And that is, of course, on top of the doubling or the 3 strike sentence. So your sentence could be doubled, plus you get the nickel prior. So
that's right.
Uh,
and I think every violent offense is also serious. So I think that 3-year enhancement stopped being used after 1982, essentially. Not entirely, but largely. Okay, so that's sort of some of the history, background, consequences. Let's turn to some of the specific things that we recommend modifying the list for. We'll start with 3 subtractions from the current list, and then go to 3 additions. So the first is robbery in some circumstances. So I think it's really helpful to look at how robbery was treated on these lists as we get into this. So it was not on that original violent list that I showed you all from 1977. It was always part of the serious list from 1982, but again, this was just in the context of the nickel prior, that 5-year enhancement. It was added to the violent list in 1987, but only aggravated robberies. You had to be essentially home invasion robberies with a weapon. So extremely aggravated robberies. And then in 2000, all robberies are made violent by Prop 21. And of course, this now includes Estes robberies, which are robberies that typically are shoplifting that get elevated to a robbery because force is used, and it can be a very minimal amount of force is used while the person is trying to leave the establishment. Perhaps a staff or security gets involved in some other situations. And it includes other less serious robberies too, including where just fear is used. So we'd propose only having robbery be serious and violent if less than minimal force was used. So we'd carve out the Estes and similar robberies, but we would still say it should be serious or violent, regardless of the amount of force used. If the victim was particularly vulnerable, e.g., was elderly or young. And of course, any robbery with injury or a weapon would still be serious or violent. So this is the most complicated one. So I wanted to start with it while we had more energy, but that's sort of the initial idea. And of course, the committee recommended in our 2020 report that we should sort of readjust the definition of robbery to reflect this. And there was a bill introduced to do that didn't succeed. So this is, in that same vein, but it's more targeted at these lifelong consequences that we looked at. And I think this is especially relevant when we think about that attempts are also serious. So an attempted robbery would qualify as a strike offense, and a lot of juvenile adjudications are also can be used as strike offenses. So an attempted Estes robbery by a 16-year-old kid is a strike for the rest of their life, and this would help address that. So that's the idea on robberies. The next subtraction is much more straightforward. It's criminal threats. So this is a serious offense currently. It was made serious in 2000 by that same voter initiative that made all robberies violent, Prop 21. It's a wobbler, meaning that the same facts can be charged as a misdemeanor or a felony based on the prosecutor's discretion. Criminal threats, they don't require any physical contact or causing injury, and you don't even need to actually have the intent to carry out the threat. So we're not proposing that criminal threats not be made a felony or changing the sentencing scheme, just that they be taken off the serious list. And I think one reason we're really motivated to do this is in our research for this, we heard a lot of criminal threat or people with mental health issues, serious mental health issues can be charged with this offense. And it doesn't seem appropriate to treat that scenario the same as we do, some of the more serious offenses on this list. Last subtraction, grand theft involving a firearm. So this was added to the serious list in 1989. And I think when you read this, at least when I first read it, I said, oh, well, this is grand theft, use a gun to rob someone, essentially. Why is it on here? It seems duplicative of other things, but that's sort of the nature of the serious list. But what courts have actually said is that this includes offenses where the firearm is a weapon or is the object of the crime. So theft of a firearm is a serious offense, and that just doesn't seem to be an appropriate balancing of all the consequences. So those are the three things we suggest taking off. Three things we suggest adding are threats or retaliation against the victim or witness, Penal Code Section 140. We say this should be serious. Right now, Penal Code 136.1, which is a very similar statute involving witness intimidation, is serious, and that seems appropriate. And so we sort of bring parity to those two different offenses. The other addition has to do with sex offenses punishing non-consensual acts. So right now, we have this array of different offenses for particularly different sexual acts, and then each of those has different ways of committing them. So we have rape, sodomy, oral copulation, sexual penetration, then you can commit that by force if the victim is unconscious, lacks capacity, is intoxicated. It's really carved up. It's all treated very inconsistently on the serious and violent felony list. For example, all rape is serious, but only some variants of the other offenses are serious. And rape by force and intoxication is violent, but the other offenses by intoxication are not violent. So essentially, we would say these should all be serious and violent. It doesn't really matter what the particular act was or the particular way it was conducted was, as long as it was non-consensual. There shouldn't be these distinctions in the serious and violent list, if we're going to have these lists at all. And the last one is also something I don't think that occurs too much, but is Penal Code 267, which is abduction of a minor for prostitution. We would suggest making this serious. Right now, human trafficking of a minor, which is the most recent addition to the serious list, is serious, and there doesn't seem to be any reason to distinguish. So those are our three suggested additions and three subtractions. So we can talk more about these later. We sort of wanted to plant the seed and have folks think about those. All right, now you get to hear from Rick.
All right, thanks, Ken. So, as you can see, we have a lot of All right. Oh, you're going to keep it up for me. Okay, great. Thanks, Tom. Okay, so I'm going to shift gears and talk about the current victims' rights and services landscape, starting with the victims' rights and services established in our Penal Code. Victims have important rights enshrined in California's Constitution, including the right to receive notice of certain court proceedings if they asked, and to speak at certain court and parole proceedings and have their opinions and concerns considered before a sentence or parole decision. And in addition to those Marsy's Law rights, there are several different support services, such as family justice centers and the California Victim Compensation Board, that are established by law and supported by state funding. And one of the services that we highlight in our memo are these child advocacy centers, which provide child focused interviews and trauma informed service coordination for children who are victims or witnesses of crimes. And even with all the rights and services established, there are several challenges that remain. And some of those that we've identified include that notice to victims isn't always reliable. So they aren't always aware of the rights that they have, particularly in the right to be heard at about a plea decision, or a sentencing. They're often uninformed of those things. Access to CACs varies by county. They're not available in every county. Every county that has them doesn't always use them, even when they are available. And then finally, funding for services has dropped dramatically in recent years, 80% since 2018. So, to address some of these gaps, our first proposal focuses on consistent use of CACs across all counties. Under this proposal, every county would be required to either establish or participate in a CAC, and in investigations involving abuse or exploitation of minors, interviews of child victims or witnesses would have to occur in these centers unless there's a good reason not to do so, such as an emergency or staffing limitations. The goal of this proposal is consistency and better support for child victims and witnesses of crime across the state. In addition to improving access to CACs, we want to ensure that victims have a stronger voice in court in relation to protective orders. So, our next proposal would guarantee victims the right to be heard whenever a protective order is issued or modified, including in post conviction proceedings. Of course, judges would need to consider the victim's safety and whether, when they come in and ask for modification, or they're heard on the issuance of a protective order, that they're not being coerced. But right now, there's no provision in Marsy's Law or in statute that says victims have a right to be heard. That when they come to court and say, "I'd like to be heard on a protective order," that the court should listen to them, and what the court should consider in listening to the victim. So this is to provide more clarity and to ensure that victims' perspectives are central to decision making in this area. So our panelists that we have will discuss more of these about these topics, and we're looking forward to more of the discussion.
That's it from us, Meg. We're ready for CPL now.
Um, Thank you. I mean, as always, you guys do an excellent job. I just want to say one thing about adding to the serious and violent list. It frequently gets framed as expanding the three strikes law, which in some ways it is, but in other ways it isn't. And I think that we've tried to strike a balance. Our staff has tried to strike a balance about, trying to make these things a little bit more rational. All right. Now we're going to hear from our folks at the California Policy Lab, specifically Manny Prunty and Alyssa Skog. I want to just, before we begin, also just say that, was it last week or 2 weeks ago when when the report that really CPL published, and Alyssa, you gave us a preview of this last year, but it's almost a series of reports on the outcomes from 5 or 6 of the largest resentencing laws that California has passed over the past dozen years. It includes, among other things, recidivism rates and demographic breakdowns. And it's really quite an exhaustive survey. And thank you guys all. I believe in this, it's this first kind of 2 reports. There's a forthcoming report on Prop 57. If I'm doing my math right, in total, we're talking about close to 15,000 people who've gotten reduced sentences under all these reforms combined. Is that right, Alyssa? You're shaking your head.
It might be more because it's 12,000 under the 5 we released. So I think it may be a little higher than that, but yes.
Okay, all right, so maybe closer to 20,000, many thousand. You know, it is certainly not responsible for all of the prison decline in population over the past dozen years, but it hasn't hurt. And I also want to, of course, recognize that crime rates have remained at near record lows throughout this whole time. All right, with all that said, Alyssa's here, and I want to thank her for the work on this series of reports we did. And um, I, I guess I just want to hand it over to you, Alyssa, because you go take it from here.
Awesome. Thank you. Thank you, Mike. And thanks, Manny, for sharing. Good morning. Nice to see everyone. As Mike said, we're here to share some highlights from some work we've been doing around serious and violent felonies in California. So you can go next slide. Thanks, Manny. So today we're going to be focusing on trends in prison admissions for these offenses using data from CDCR. And we're also going to look at some arrest and sentencing trends using data from the California Department of Justice. But I do want to flag that there is a challenge in that DOJ doesn't explicitly categorize an offense or a case as serious or violent. And then additionally, the data from DOJ sometimes is missing key information like enhancements or degree that makes it challenging to determine whether an offense is actually serious or violent. So
Alyssa,
kind
can
of
I just jump in here? Because this has always been a curiosity of mine, and I don't know if our data reflects it or not. But CDCR flags people of having had serious or violent crimes. And I've never been clear if that's the current offense or if they've ever been convicted of a serious or violent crime. And do we know the answer to that?
the controlling offense on it is the current offense. Yes.
Gotcha. All right. Thank you.
So yes. So with DOJ, they do not explicitly categorize as they do in CDCR. So just to kind of give some context, when we're talking about, or when Manny rather is talking about admissions to CDCR, we're going to be talking about the universe of all serious or violent felonies. But with the DOJ data, we are going to limit what we present today to 4 specific offenses. So 3 in which it's clear cut, 2 which were on Tom's list. So robbery, criminal threats, and assault with a firearm. And we're also going to include assault with a deadly weapon due to its volume and because it's most often serious or violent. So with that kind of data disclaimer in mind, I'm going to hand it off to Manny to walk us through the data.
Great. Thanks, Alyssa. So now I'll be showing figures we made using the DOJ data. First, starting with the arrest frequencies from 2014 to 2023 for those 4 aforementioned offenses. And we can see that largely the trends remain relatively stable across the time period, with the exception being robbery, where we see a large decline during the pandemic and then a slight increase in those arrests by 2023, but has not rebounded to the pre-pandemic levels. Next, we were interested to see if the share of felony arrests for those 4 offenses matched the trends of the frequencies. And we can see that they largely do, again, except for robbery, where the share of felony arrests for robbery is actually higher in 2023 than the pre-pandemic levels, unlike the frequencies. Next, we're interested in the felony arrest shares by race for that same time period for those 4 offenses. And across the 4 races, we can see that the arrest shares for those 4 offenses were similar across races, with the exception being the share of arrests for robbery for Black people, with 7% being more than double the next closest for Hispanic people at 3.4%. Next, we're interested in the share of convictions that result in a prison sentence by race and ethnicity for those 4 offenses. Overall, we can see that assault with gun on the left-hand side largely results in sentence to prison, unlike criminal threats, or specifically assault with gun convictions are more likely to go to prison than criminal threat convictions. And then by race, we can see that the blue and orange bar for Hispanic and Black people are usually going to prison at a higher rate for those convictions for these offenses. And now I'll be going through figures made using CDCR data. As Alyssa mentioned, there's a specific indicator for the felony type, unlike DOJ. So I'll be mentioning that in the figures.
So first, we're showing the CDCR emissions from 2014 to 2024 now, not 2023. And we have the non-serious felony emissions, serious felony emissions, of violent felony emissions, and all violent felonies are also serious. And again, these categories are mutually exclusive. So the majority of emissions are for non-serious felonies across this time period. Next, we're interested in the variation in emission severity by race for the same time period. So the darkest bar is the violent share, followed by the serious share and then the non-serious share. And we can see that the violent share for non-white people is much higher than the violent share for white people. The serious share is pretty similar across all races, and then the non-serious share is much higher for white people compared to non-white people. Next, we're interested in just seeing the overall trend in emissions to CDCR for serious or violent offenses or violent felonies. And we can see that pre-pandemic, there was a small gap between violent emissions and serious emissions, where violent emissions were consistently higher than serious emissions. Both took a drastic decline during the pandemic. But after the pandemic, the gap between violent emissions and serious emissions increased compared to pre-pandemic, where violent emissions are much higher than serious emissions, about a 2,000 emissions gap between the two in 2023 or 2024. And lastly, I'm showing you here the serious and violent emissions for most common offenses in 2024. So first, starting on the left with serious emissions, and these are the 5 most common offenses for serious emissions. And we can see by far the most common are assault with a deadly weapon, burglary, and criminal threats. And then there's a substantial drop off to the next closest, which is assault with a gun at 200 emissions. And then for violent emissions, the most common offense is second-degree robbery at almost 1,500 emissions. And then there's a large drop off to the next closest at manslaughter, manslaughter with 570 emissions. And that's all we have. Thank you.
All right, I have a couple of questions before moving on. I don't know if anybody, the other committee members do, but I'm just going to dive in. First of all, I'm going to plug our data dashboard, I guess, which is, again, we're sort of in beta launch of that. I encourage everybody to check out californiaprison.data.org, where a lot of this data can be sorted on your own. But I have a couple of questions. At the end of your presentation, Alyssa, you mentioned that assault with a deadly weapon was almost always serious or violent, or is it almost always violent? What were you saying there? And I know that this often comes back when folks want to challenge if the list is appropriate and they say, well, assault with a deadly weapon isn't serious or violent. Can you just unpack that a little bit and explain what you were saying?
Sure. So Manny, one of the ways we did this was Manny kind of checked to see how frequently these offenses appear as serious or violent in the CDCR data, since we can actually observe that classification. And Manny, correct me if I'm wrong, but it was 80% of the assault with a deadly weapon was it either serious or violent, or was it one of those two, if you recall?
At least serious.
At least serious.
Yeah.
So 80% of ADW cases were serious.
That were admitted to prison, yes.
And 20% were non-serious, non-violent, or were 20 of them also violent?
20% were non-serious.
Non-serious, non-violent.
Yeah.
And the reason why they can get bumped up to serious, right, is because if there's a certain like great bodily injury enhancement, or right, is that, or use with a gun? Is that how it works?
I believe that's correct. And Tom knows better. But there's facts of the case that we can't quite observe that we can't observe in the data, and that's kind of what the distinction is, I believe. Is that correct, Tom?
They have to plead and prove that, well, that the person personally used a deadly weapon.
Right, and great bodily
Is that what
injury.
you're gonna say, Tom?
It's a little bit of a mystery, because any assault with a deadly weapon is serious, but the assault with a deadly weapon statute also talks about dangerous instruments. What the distinction between those things is, it seems very theological almost. So I was surprised that 20% of people going to prison with an ADW, it was non-serious or non-violent. I suspect it might just be a result of plea bargaining and things like that. But assault with a deadly weapon on itself is serious, even if without an injury out enhancement or whatever. So I don't. To me, it's a little bit of a mystery. I was surprised to see that.
All right. Well, I think that is actually something that people frequently approach me about, at least about assault with a deadly weapon. I don't know if it's possible to break this out and figure it out a little bit more, Tom, Alyssa, and Manny, but I think that I would try.
Got it.
So I just want to add that. I also, a couple things for Manny. Manny,
Yes.
you had a slide about assault with a gun and broken down by race. All right. And I just want to say that the racial disparity here, again, with the assault with a gun, to me, really jumps out in light of the Racial Justice Act. We sort of now are beginning to sort of take this for granted almost, and I just can't stand it. I also can't stand that the Racial Justice Act, which was passed with a recommendation of this committee, hasn't been able to address it. Tom, Rick, anybody correct me if I'm wrong. I don't think that there's been a single successful RJA claim to address this kind of sentencing disparity. I just wanted to flag that for everybody's concern. I don't know what can or should be done about it, but I don't want it to go without mention. And then finally, Manny, you also had a slide about the admissions, whether it was serious, non-serious, violent. No, yep. All right. To me, let me make sure I understand this correctly. So the current offense is non-serious or violent, but the only reason why you get admitted to CDCR in the first place is because you have a prior serious or violent. Is that correct?
Yes, or some non-serious, non-violent offenses still require a prison sentence too.
Yeah.
Right, but those are rare. I mean, why is that blue? That's counterintuitive. I'm right. This blue line is far as counterintuitive. What's really driving it?
Well, it's admissions, so it's a lot of people coming in for a short amount of time, over 10 years. So if you looked at like the breakdown of the current population, it would probably look quite different.
But are there, let me put it another way, are there non-serious, non-violent crimes that are not 1170H crimes?
Yes.
And the significant number? I thought that was not that big a number, but I may be wrong.
I think it would depend upon what we define significant as. But yeah, there
Okay, I
are,
mean,
and a lot of it is driven by criminal history too. So like,
right. So is the blue chart, is the blue line, which is so much bigger, driven by the criminal history, or is it by the current offense that happens to fall between 1170H, which are realigned offenses?
Right. Yeah, that's a good question.
Yeah, and we can check that.
Okay. Those were my questions / clarifications. Does anybody else have anything that they want to add? All right. I don't see any hands. It's hard for me to see in these tiny little boxes on my screen, but I think we're all good. I cherish our relationship with CPL. I love it when you guys come. Thank you so much. I think you guys add so much to the committee and what we do, and I really look forward to continuing that relationship, in the future. And thank you to the legislature who is now funding CPL. Thank you to Arnold Ventures who, I guess, sort of seeded that. So anyway, this has been great. Thank you all, and appreciate your time. All right, moving right along. We're now going to hear from District Attorney Dan Dow. Is he with us?
Yes.
Don't see him, but
he's coming there. Yeah.
I trust you. Okay. Hi, DA Dow. He is, of course, the elected prosecutor from San Luis Obispo, but I also wanted to add. Well, he's also, if he looks familiar to everybody, he's been here before and not that long ago. But you're now also the president of the California District Attorneys Association, which is obviously an influential body here. We really appreciate you coming, not just this time, but as it was ever. We want to hear, and today your topic is sort of victim rights and priorities of how we can make victims feel, I guess, either more whole, or more accounted for in the legal system. Is that fair setup for you, DA Dow?
Yes, it is. Thank you.
All right, thank you.
Yeah, thank you, Mr. Chair. And how much time do I have, if I might ask?
Tom is the timekeeper.
I think we scheduled roughly 15 minutes for everything. You know, we usually try to have a few minutes of uninterrupted argument before questions start, but whatever works for you.
Well, I
Yeah,
just want to,
let me just jump in there on that. Let's assume that we have 15 minutes. I think ideally for us, if you could sort of split that somewhat half and half, we'll give you 7 or 8 minutes to chat. But I really do think that the Q&A session is maybe certainly valuable to me. So
perfect. Yeah, that's great. And would I be able to share my screen to show a couple of slides?
Definitely.
Let me just see if looks like I have that ability. And are you able to see that?
Looks
Yes.
great.
Okay. Well, again, I want to thank all the commissioners committee members for allowing me to be here. And I appreciated the discussion that you had previously. I might just comment that some of those state prison commitments that are not violent and not serious remember, they're status-based. So there's sex offenders that would still go there for other offenses. So there are at least some other just status-based crimes that would cause someone to go to state prison instead of a county jail.
just to make sure I understand, based on their prior offense.
Correct.
Yes.
Yes. So if they happen to be a 290 registrant, that's one of the qualifying factors to make them ineligible from 1170H.
Right, regardless of what their current offense is. I think likewise, if you have any serious or prior felony, right?
Yes, I think there might be a limited exception, but yes, I think that's generally correct. And the other thing is there is an assault with force likely to produce great bodily injury that does not require a weapon to be used, but it's, you know, a physical beating perhaps where it was likely to produce GBI. GBI was not pled or proved, and that would be a non-serious assault under the same section where it's assault with a deadly weapon, a PC 245. So that's another example that I thought of as you were discussing. But my reason I think that I was invited to speak today is that as the incoming president of CDAA, I gave a training at our summer conference about Marcy's rights because we had a case in our community, unfortunately, where it became clear to me that there's rather probably a more routine than any of us would like to acknowledge place for improvement. And that is that victims' specific rights to be heard at a particular time in the proceeding. And it's in our Constitution, which judges take an oath to ensure that those rights are provided, as do all of the attorneys, obviously. And I bring that up just because what my ultimate ask or recommendation would be is that there be a new requirement by statute or potentially by case law, if an appellate court would impose it, a requirement that the judge at the time of a plea being entered would also ask the people's representative, the person there, maybe a Marcy's rights lawyer on behalf of the victim, ensuring that that victim is aware of the terms of the plea offer, and to find out whether or not they object to it and want to be heard. Unfortunately, due to congestion and calendars being very jammed, and also because oftentimes a defense attorney and their client may be willing to accept a plea at kind of on spur of the moment, when a victim has not been advised that that's likely to happen, they're not in court. And so we had essentially a case that was scheduled for trial, confirmed for trial, a police officer, female police officer victim who became medically retired because of the injuries in her case. Our office knew that she objected to the plea offer, but we hadn't advised the court of that. And the offer had been rejected. And so it was only after a length of time and the trial was confirmed that suddenly the defense said, hey, we want to take that prior offer. It wasn't intentional, but that victim was not contacted and advised, hey, there's going to now be a change of plea. Instead of you coming to trial next week, if you would like to be here and advise the court of your objection to this proposed plea agreement, then, you know, you can come down here, or at least giving that person a call on the phone. And so what I learned through this is that unintentionally victims' rights can be not provided to them, and yet they're written in our Constitution, passed overwhelmingly by the people. So these are just a few of the slides. I'm not going to get into all of the facts of the case, but I've, on my own, and other people smarter than me may divide the enumerated rights up differently, but upon my analysis, I categorize them as there are three kind of subjective general rights for how a victim should be treated. But these kind of are the framework for all of the others: fairness, respect, privacy, dignity, protection through the process, protection from the defendant and any third parties, also a right to a speedy trial, prompt conclusion, sentencing, and appeal. And then 14 of the other being more objective, where they're specific procedural rights and personal to the victim, where they're almost treated as though they're a party, at least in substance in the text of the Marsy's Law. They have the rights to advance notice to be heard by a court. Confidential information is protected from being disclosed, to provide input to a probation officer for preparing a sentencing report, this kind of thing. Obviously, restitution and return of property. But there are 12 of those 14 that are certain rights at a particular time and place. This is akin to the right to appear at the hearing, any hearing, but specifically at the time that a plea is going to be entered or changed. And this is where it says they have a right to be present, but also to be heard. And I would argue, I heard the earlier presentation about a restraining order change, and that victims don't have a right to be there. I believe they do under Marsy's Law. I just think it's not, as a matter of practice, enforced the way that it should be, perhaps by the bench officers. But of these 12 that are certain time and certain place, it's the time of the setting of bail, when the charges are filed. They have a right to confer with the prosecutor before we even make a filing decision. So some of these are more implied in the hands of the DA, if you will, to ensure that they're being heard. But to be present at all public proceedings. If the judge has not asked the DA, does the victim know about, you know, this hearing and want to be here? And if the DA doesn't on their own advise the court of that, a hearing gets called, it's completed, and the victims have been an afterthought. And so one of the theme that I have actually created for this year for California District Attorneys Association is not victims first, because I don't necessarily agree that victims are first. There's a lot of very important rights, obviously, with the defendant. And so, but the phrase that I chose was victims always. That whether it's at an arraignment, whether it's at a plea, whether it's at a sentencing, or in the case proposed at a restraining order change, that victim should be thought of and considered and given an opportunity to be heard. The issue with the case that we had, and why I think it's so significant, and the Daily Journal wrote a good article about it, and we have a written denial of our writ on the issue, but we have one Justice Yagan wrote a really compelling, I think, dissent in there, where he supports this idea that victims' rights are so important that it would even allow for undoing of a plea to go back and give the victim their substantive right if it were violated. In other words, if they were not heard at the time of plea, and if they objected to the proposed outcome. So, and I'm kind of short on time here before we kick it back to a discussion, but in my office, we are now, I'm going to jump down here. We are now advising the court proactively at the time of the plea. Your Honor, the victim has been informed of his or her Marsy's rights. The victim has requested to have this particular right to be afforded. They want to be here today. They have not now been informed that now is the time for the plea, because I just learned that from defense counsel. They do want to be heard, and so I'm going to ask the court to allow us to either put it over till this afternoon to give time for the victim to come in, or if we're not able to make contact, that we put the case over to another date, at which time the victim's right can be enforced. And so it's my hope that your committee would consider the fact that with all the discussion about changes regarding punishment and equity in sentencing and that sort of thing, that we don't lose sight of the tremendous impact of each one of these crimes on victims, so that their California constitutional rights are not violated. And so the alternative is that if there were a new requirement by a revision to current law, it might suggest or might require that the judge do an inquiry like they do when they do a rights inquiry for a defendant. When they ask the defendant, are you healthy and well? Have you had enough time to talk to your lawyer? Do you understand the charges? Do you know your right to a trial? Do you know your right to call witnesses? They do that, and they should do that. That's clear. I would argue that they should also do it with respect to the enumerated Marcy's rights by asking either the DA, or if the victim has retained a Marcy's Law counsel, if they're present, ask them, or the victim themselves if they're in the courtroom. And so the questions would be, has the victim been informed of their Marcy's rights? Have they requested to have those rights afforded to them? Have they been informed that now is the time for the plea? And do they want to be heard, or do they waive that right to be heard? As you know, language is powerful. A number of years ago, I came up with this idea because of actually my assistant came up with the idea, and I implemented it here, is that we've changed the way we refer to the justice system to be the criminal and victim justice system, because each crime affects a victim, even if it's a property crime, and justice should serve both. And so that's kind of my overall presentation in terms of themes and messages. I hope that you'll be open to kind of considering this. I think it would go a long way. I believe that the California public had told us last year with Prop 36, for instance, that they are very cognizant of things not always seeming just and fair, and that victims are often at least subtly not prioritized. And I think this is something that could go a long way to provide meaningful respect, those more subjective rights that I talked about at the beginning, fairness, treating with dignity throughout the process. So I will stop sharing and turn it back to you.
Yeah, so I think a lot of this makes sense. Actually, Heidi and I were involved in a case this summer with quite a bit of issues about Marcy's Law. I won't get into here, but I think both of us, well, I speak for myself, about that Marcy's Law comes up very often. It seems quite sweeping, and yet there's no enforcement mechanism whatsoever to do this, and it includes a lot of these kind of vague rights, like you were saying before, about fairness and respect and dignity. That of course we all want to give to everybody, but then how do we make sure it happens? So my understanding, DA Dow, is I guess your, at least an attempt to come part way, is to, for a statute that would require judges to ensure that prosecutors have reached out to victims or try to reach victims in every case, to make sure that they understand their Marcy's Law right. Is that a fair way of putting your proposal?
Well, I think so, but I think it's rather than ensuring that the prosecutor does it, is that the judge, just like, they are specifically inquiring of the defendant's rights, that they're specifically inquiring about the victim's rights, to show that they're recognizing those rights are still tantamount to justice, as they are for the defendant in their case. But because the law doesn't say the DA shall do all of these things, it is a right that's inherent to victims, and that anyone in the justice system really is obligated to work toward.
No, I appreciate that, and you're trying to put some meat on the bones or make it enforceable or
Yes.
implement it. So let me just I want to make sure I understand your proposal. The proposal is that the judge ask the DA, have you informed the victim of their Marcy's Law rights?
Correct. Yes.
And if the DA says, no, I have not, then the proceedings are paused until they can do so.
Yes.
Okay.
Right.
That seems rational to me. And like I said before, this Marcy's law is this sweeping law and a part of our Constitution, which almost has no enforceability. So I think to find a way to make it implement it makes sense. However, it seems to me there are so many cases. I mean, are we talking about misdemeanors that get resolved on plea at quite quick clip, that having this kind of notice requirement and waiting, you would know better than I, but my hunch would be that this would be pretty onerous on the system.
Well, and I appreciate that. On the one hand, every victim has this same right, just like every defendant has the right not to incriminate themselves and the right to a jury trial. So on the one hand, it's kind of, the volume and the complexity doesn't really take away from the right. But as a practical matter, I talked with Mr. Nosevich and Mr. Owen prior to this meeting, and we talked about potentially having it be done on felonies, exclusively maybe at the beginning. I could envision that, like with a DUI, the law requires that if a district attorney pleads a DUI down to a wet reckless, that wet reckless is not a substantive offense that can ever be charged as a primary offense, but only if the DA has filed what's called a prosecutor's reduction statement. So it might be that the requirement on DAs would be that they submit a form on misdemeanor cases where it affirms that the victims have been notified. And I can tell you, as the president of CDAA, we take that obligation very seriously. We work incredibly hard. Unfortunately, no profession is perfect. And so there are times when they might not be enforced. But I think with a statutory requirement, it would help provide the substance to ensuring that these rights are being thought of and considered, and judges aren't just forgetting about it because nobody brought it up. And so I could see the DA maybe submitting a form, or the victim on their own submitting a form to the court on a case. But I guess I would leave it up to the committee to come up with what you think would be the way to phase it in. I think clearly on a felony case, I think it's important enough to have that colloquy be done in every case, just as it is for the defendant.
And since you brought it up, what about a case like a DUI case where the victim may not be as obvious?
Well, and I think that, if the victim is just the people generally, I think, I don't think Marcy's law is going to really be enforceable in any kind of a concrete way. But it's when there's a named victim, a property owner, a business owner, a assault victim.
Of course, we understand those type of obvious
Right.
victims. So again, just to try to craft this proposal a little bit more. So when there's a named victim, perhaps we keep it to felonies. I understand that you would want it to go all the way down to misdemeanors. I would want to speak with some other folks, some judges, perhaps Judge Espinoza. I'm curious what your take is on how this would work, just practically. Would it really, could we do this without totally gumming everything up? But I want to say, DA Dow, I share with you at least my surprise about that Marcy's law is enshrined in our Constitution, yet seems to have no teeth and very little applicability, absent DA's offices who are sort of going out of their way. And they probably were doing it anyway before Marcy's law. So,
Right.
So anyway, with that said, Mary, you had your hand raised.
Well, even with felonies, my concern to some extent was how long are you going to delay to wait for the victim? Because what if the plea includes a time served, or the person is currently incarcerated and they're going to get out of jail because even in felonies, you can have a plea where it's the person's been in jail for some period of time, or they're going to have probation. And so if a plea has been agreed to and the victim is out of town and needs to come back or can't make it for a couple of weeks, are you talking about someone doing more time in jail where they would have been out potentially, and back to taking care of their family or taking care of their children or doing other things? And so I think I get the idea that, the initiative passed and there was, it was enshrined in law. As you all know, the initiatives are not always drafted well, which is why there's probably no thing, but there are, even in felony situations, times where the plea is going to get the person out of jail and not just send them to prison. And so a delay, because a plea was agreed to and the victim couldn't be there, or the victim chose not to show up that time, or the DA was not communicated, seems not correct.
As a ballot measure author, I take some offense about the sloppiness of what. No, but the serious question, DA Dow, how do we deal with this kind of situation where the delay really does seem to might keep people in prison longer or jail?
Well, on that case, I hear what you're saying, but I would argue the opposite effect. If the victim doesn't know that an offender is about to be released, and in the instance where it's been a violent crime or a crime of some kind of direct crime committed against a person, they even have more of a right to be there and to be heard about it. And if they didn't know the case was going to resolve, what we're talking about is the DA going out with the phone call, out into the hallway, making a phone call in most cases. And only, I think, in a few cases would it be that, one, we can't reach them the same day, or they really want to be here and they happen to be out of town. And I think as long as the law were to allow for a judge to make a decision based on a reasonable amount of time, like they do with a lot of other reasons to continue things, that the judges would protect the defendant's interest in that situation and ensure that it wouldn't be unfair to the defendant.
Okay, so we say some reasonable time limit. Is there a reason that we can't do this earlier in the process, somewhat at arraignment, saying, DA, okay, we're at arraignment, you have a responsibility to make sure the victim is reached out to before we get too far down the road?
Well, as I was alluding to in the presentation, these are rights that they don't, it's not just a once and for all, they're notified. They have a right to appear and be heard at every hearing. So if, as I said, in our case, it was set for a confirmation, it was a second trial confirmation hearing. They had already confirmed it for trial.
I'm sorry to interrupt. I understand the edge case. I understand how things can go sideways. But the point is, this is a law that affects, every crime victim, almost every offense. I'm thinking sort of in the mass cases. Is there a way that we can do some preloading so it doesn't create the problem that Mary was talking about, that we're waiting for? So tell the DA in advance, hey, you got to do this, right?
Well,
we're going to be back.
I think honestly, where we would get the most impact, where victims would feel the most respect from the court in the system, would be if at every time of plea, the judge, if the DA and the defense attorney knew this question was going to be asked, I pretty much guarantee you the work will be done and people will know ahead of time this is going to be a time of plea, and they will come. I don't think you could accomplish it at an earlier stage. It's a substantive right, procedural right at the time that plea is entered. And frankly, to not advise the court of the victim's perspective deprives the court of information from which they may not agree to approve a negotiated plea agreement. And if the judge doesn't have that information, they're not able to make, in some cases, a decision that they would otherwise have made differently.
I appreciate it, and the right is to be there at the time. But I'm just trying to say, like, if we can preload it to say, we are going to ask you this at the time, so you better be ready. That's the kind of thing that I was suggesting. To try as much as possible to avoid Mary's problem and to, you get where I'm going. And
yes.
It seems like you think that that's not the right fix, but.
Well, I think as long as, I think changing the law to require that the colloquy happen, I think will change the behavior in the courtroom. It'll help the judges now remember that this is important for them to take part in, and the judges doing that will help the DAs. And I think now our criminal and victim justice system culture has changed to where we're all cognizant that the victim's rights are incredibly important as they're grounded in the Constitution.
Of course. Judge Espinoza.
Yeah, I think what DA Dow is describing is a cultural change, and I think that's what needs to occur. The DAs need to know that when they're about to present a plea agreement, that they're going to be asked this question. And I think that will change behavior. That's what I think he is saying, and I agree with that. I am concerned along with Mary, that there are going to be instances where people end up staying in custody longer. The court can always release somebody pending sentencing. That's an option. The court may not be willing to do that based on the particular facts of the case. But here's the thing and now I'm falling into my court management mode. It's trial day. You've got 100 citizens who've been brought into the building to be considered as prospective jurors on the case. A plea deal is struck, but nobody knows where the victim is. What do you do in that instance? And I'd be interested to hear what the DA has to say about that, because getting 100 of our fellow citizens in for a jury trial on a serious felony, it's no easy feat. It's a lot of work by court staff to get to that moment. So I have some concern about that, but I don't think that's going to happen all that often. But it's another instance where it may be difficult for us to accommodate a victim who's not available. But otherwise, I agree that we're just talking about a culture change here. And I think that if the DAs know the court's going to ask, the DA is going to be ready to answer the question.
And Your Honor, I agree with that, everything you said. I think in the case of during jury selection, in most cases, and I think you said it would probably be rare, I think in most cases, those victims already know what the offer was. And finally, the defendant saw the whites of the eyes of the jurors and decided to go with it. I think it's going to be a very limited number where they're like, no, I want to come down there and object. I mean, they're always going to have a right to come back at sentencing to have the victim impact. So that's why I wanted to really distinguish that. To me, the most important, what I learned from our unfortunate case here, is that the victim feels disrespected if they object to the proposed plea agreement. And I'm okay if a victim isn't happy. I get that they may not be. I want them to have the right to be heard, however, if the DA firmly believes this is the right agreement. And so I think the numbers, statewide, will be small, particularly on a case like that where it's the day of trial, because typically I know when I'm in trial, I'm communicating with my victim, hey, today's day one. If there's a change, I'm going to call you immediately and get you on the phone. So I think the numbers where that would be an issue are very, very low.
I think that's right.
All right, I think this makes some good deal of sense, and I think we need to think it over a little bit about misdemeanors and felonies and how it can be enforceable. And I like the idea of some reasonable timeline the judge can say, like, we're not going to hold somebody in jail because that person's in Tahiti for 2 months. Thank you. Is there any other questions for DA Dow? Oh, sorry, Heidi. Oh, you're on mute.
This is sort of a law professor hypothetical question, I fear, but I'm interested to see what you think. Would there be an opportunity for victims who want there to be a plea offer, but no plea offers being made, to be heard by the court?
I haven't I haven't come across that. So could you think of a hypothetical? Are you saying like where the DA said there's nothing we would offer, we want a plea to the sheet, kind of a scenario?
Or the DA is offering something that the accused person is not interested in taking because it's for whatever reason, and the this would obviously be a victim who's supportive of taking LWOP off the table or whatever it is, like they're pleading a death case down to LWOP, and the victim would rather see the person have an opportunity for parole at some point. But if that plea never comes up in court, if the defendant never accepts the plea, those victims don't get a chance to weigh in. I assume it would mostly be in the situation where the victim wanted a plea that was more favorable to the accused person than the DA was offering. I'm kind of throwing it out as a hypothetical, but I want to be sure that all victims' Marsy's Law rights are being met if we impose Marsy's Law rights on some victim, for some victim. We create these Marsy's Law victim rights for some victims.
Certainly, and we have that. Where we see that happen most is probably in a domestic violence case, intimate partner violence. So I would agree that can come up. I would argue, though, that right is probably being afforded right now because of what I told you. They have the right to appear at every hearing, and victims who are very invested on their many cases, it's a loved one and their family. They're typically there at every hearing, even when there's nothing substantive happening. And so they do have a right to be heard at any of these hearings. And so that's already being afforded to them. I don't know that it would come up that
Are you anticipating like the judge? I've never really seen or heard a judge say, how do you feel about what's being offered in this case? Or, how do you feel about the proposed resolution in this case? So I'm not sure. I understand they'd be present, but where is the equal opportunity for them to be heard, or, the inquiry by the judge to happen?
Well, and that's what I'm really proposing, that would be a judicial intervention, that they should be cognizant of the fact that they are keepers as well of Marcy's Law. And so I would encourage that kind of a judge to be intervening that way. They're probably going to know when a victim is coming to court numerous times on a case like that. And so I think already the mechanism is in place for it. It's our judges even being educated. I would propose that, there probably should be some additional training at the Judges College for judges on, one, this change if it happens, but two, under the current structure, what could they do to ensure that victims are more, that they have more access, equal access to justice, as we want so much in our justice system.
Thank you.
All right. Thank you, DA Dow. I think this is interesting. I think that we can chew this out. Chew on this a little bit longer. But I think that there's something here. I hope you can work with us and our staff as we, work towards a recommendation. So I really appreciate your time.
I appreciate your inviting me.
You're welcome. All right. Now we're going to hear from Tanish Hollins. Is she with us?
Yes.
Hi, Tanish. So often we hear about victims' rights from DAs and not necessarily from victims or victims groups themselves. And so Tanish is she's the executive director of Californians for Safety and Justice, and she will discuss her work and the work that of her organization that you do for the needs of crime victims and crime survivors.
Thanks. Good morning, Mike. Good morning, everyone.
Morning.
I apologize. Dealing with a little allergy, so I may pause to take a little sip of my water. My name is Tanish Hollins. I'm the executive director of Californians for Safety and Justice. I'm also the state director of our crime survivor network, Crime Survivors Speak. We have over 50,000 members in California. I am a survivor of crime. I've lost 2 members of my immediate family to gun violence. And I also know the trauma associated with victimization and what happens when that trauma goes unaddressed. I've lost a member of my family to a mental health crisis as a result of that. I've been an organizer around public safety and community for a very long time and have worked on these issues for a very long time. I appreciate the work that you all do, and even the conversation and the presentation led by DA Dow just a moment ago, because victims' rights are extremely important. And in listening to the conversation, just realize how narrow and sometimes inadequate victims' rights continue to be. There's still so much work that we need to do. So much of the victims' rights and advocacy are still narrow and tailored to process and procedure, limited around notification and information and engagement in a process. But we know that there is still so much more that survivors need beyond just punishment. We know that punishment doesn't equal support. Our work through Californians for Safety and Justice and in our Crime Survivor Network has been around expanding rights and protections and support for victims of crime. This includes preventing crime from happening and dealing with the drivers of crime, but also expanding access to support through trauma recovery, making sure that folks have access at the local level and in community, and that their voices are also informed in shaping policy, not just around victims' rights and protection, but also in criminal justice and criminal justice reform. We don't want the conversation around victims to just be symbolic. We want it to be substantive. And so that really requires that we look at safety and healing and long-term stability. Unfortunately, that doesn't always make its way into conversations around penal review. There's only so much that we can do to make sure that folks understand their rights and that they're engaged in a process. But it does very little to talk about the long-term safety and well-being of survivors. And this is where our work actually comes in. It's to look at that conversation more holistically and find ways to address those gaps. One of those ways that we do that is by removing barriers to access for survivors. One of the challenges that we have around that is how victims are identified in the first place. And a lot of that really depends on whether or not someone is identified as a victim of crime on a police report. We know that too many crimes are unreported. Too many individuals who have been impacted by a crime or have been a victim of a crime are never identified as a victim of crime or have their victimization erased, which means that they are not engaged in the process and never receive access to the support. And we know that in many ways contributes to the public safety crisis that a lot of folks are concerned about right now. So our work stands at that intersection by giving that identity to folks who often don't receive it, but also bringing them into consideration into our policy conversations around expanding that protection and access to them by making services through trauma recovery available to them. We don't have to worry about getting a police report to substantiate a victim experience when a survivor can talk directly to a social worker or to a doctor or to a counselor to substantiate their victim experience. And we know that when survivors are heard and engaged that way, research shows that they are sometimes more likely to cooperate in a legal process where they are willing to go to trial and participate in a criminal proceeding. So these are the types of engagements that we like to continue to encourage. We also want to, continue our work around, sorry, I'm having an issue here with my computer. We also want to continue our work around expanding opportunities for justice and accountability. We know that most survivors want what happened to them to never happen to anyone else. We understand that accountability is a layered conversation and that our justice system is too narrow to offer that right now. And a lot of reactive policies, many of which you all talk about in these discussions, have really resulted in the overrepresentation of Black and Brown and disenfranchised folks in our criminal justice system, but have done very little to deliver safety to our communities, which is why we still see a lot of the same challenges in some of our communities right now. So we want to reverse those trends by dealing with things at the root level. If we can address trauma, if we can provide immediate assistance to people who have been victimized and been harmed, if we can create more options for accountability, if we can bring in real rehabilitation to address the issues that folks go into the criminal legal system with, and we can do more prevention on the front end, then that's going to create the kind of safety we want to see. And when we talk to survivors in our network, including those who may not be completely aligned with some of the conversations that we have around criminal justice reform, we see a lot of alignment in our agreement on what it's going to take for us to achieve safety. So these are the kind of holistic conversations we're going to continue pushing around. There's agreement that the majority of survivors of crime don't receive victims' compensation. That's still a challenge that we're going to continue to work on. That the majority of survivors are still not being informed or engaged around their rights. And that the majority of survivors, even if they're going through a criminal proceeding and they receive justice through the criminal legal system, are still not receiving justice and closure and support in the long term. And these are things that we're continuing to work on through our network and through our policy change. So I just wanted to be able to offer that to this conversation. Thank you all for inviting me to be here today.
Thank you all, Tanish. Thank you, Tanish. It's good to see you. Um, Something that I struggle with, and I was wondering if you could point us in a good direction, is so much of what I think would help victims and what you're talking about, support services, prevention, they're harder to put into statute than adding 4 years to a robbery conviction sentence. And I was wondering if you knew of either in California or around the country things that you're like, that's actually kind of a clever way to address some one of these needs in a very actionable and legislative sort of fashion, because like it or not, that's where most of our recommendations end up. So I was wondering if there's anything in particular that stood out to you as something that California could be doing better, or that maybe some other state is doing better than us that we should mimic.
I mean, we're complicated here. But some of the best models that we see are, in the community court levels when we're able to utilize those types of interventions. And back in the day when I was able to participate and a volunteer in a lot of our juvenile proceedings, having neighbors and having individuals who can participate in a conversation around what accountability could look like presented more options. Unfortunately, when we get into more serious offenses, we don't have that option. And that is part of our challenge. How do we, begin to think about how we make changes in our justice system that allow for more options for accountability? We also see this when we have conversations in our victim offender dialogues. It's clear that folks want accountability. And I'm saying this as someone who has experienced harm. Just because I'm advocating for criminal justice reform doesn't mean that we don't have an issue and that folks should not be held accountable. But we don't have enough options for accountability. And I think that is where we need to continue fine tuning our work. And so those models should be considered. We don't have enough levers and we don't have enough willingness for folks to be able to utilize those models, especially in serious offenses.
Yeah. I also think sometimes this conversation also gets not to, of course, people who are victims of serious or violent crimes, suffer extraordinary harm that almost can never be repaired. But the vast majority of crime victims are property crime victims. And was it last year, Tom? Can you remind me? Was it Vermont or was it Washington? It's one of those states that had this very progressive idea of like, let's just pay everybody back who was a victim of a property crime. Can you refresh us on that and where that stood?
It was Vermont, and it was restitution. So you had to, have someone convicted in the court process, which, is a fraction of the actual crime. But yes, that was the idea, is that the state would pay restitution in the first instance. And then, this committee made a similar recommendation that California should do that and then worry about collecting from the defendant if it made sense. But the victim shouldn't have to deal with that process of literally getting checks for, a few dollars or less than $1 over a long period of time.
Right. And did anybody take up that proposal, or was that not even become a bill?
It was very expensive, so it didn't yet enter the legislative arena.
All right.
It's interesting you brought that up, Mike, because I've had conversations with members of different chambers of commerce around the state and small business associations across the state. Obviously, last year as Prop 36 was on the ballot, and even before then, and as a small business owner myself, outside of the work that I do, most folks were most concerned about just being able to keep their doors open and stay in business, and obviously concerned about the quality of life issues, but did not see sending someone to prison for 10 years for breaking their windows out or even vandalizing, robbing their business as the solution, right? So on the more immediate end, people needed help to stabilize, to get back into business. For people who were harmed, if they were a victim personally, if they were harmed in the incident, obviously they needed immediate help, to physically heal, to feel safe. And again, there were no options available to them. So I think this is a conversation worth having on what additional kind of levers can be pulled to provide people who have different victimization experiences immediate support. There's also a really unique thing that was happening in San Francisco about 2 years ago on property crimes, where neighbors were coming together and kind of doing, they were kind of doing in kind. People's bikes were getting stolen and they were just replacing folks' bikes.
Yeah, that's
They were air tagging things, and if they were able to find them, people were just going out on their own search missions and recovering things, right? And so I think simple is always the best way, and the criminal legal system is not simple.
No, I agree. And again, I don't want to put people who've suffered, who are violent and serious crime victims, but because there's so many shop owners who I assume they want their window fixed. That's number one. You know, they want their bike back. And we are so bad at that, but you know, good at lots of other things that I think perpetuate more harm. I know that California Center for Safety and Justice has done a number of surveys of crime victims, and I was wondering, are all those on your website? Are those things that you can share with us? Is there anything recent, or are those all dated? Can you sort of give us up to speed on that?
We're actually, Crime Survivor Speak is facilitating a survey right now with our members about access to victims' compensation. I think the data from that will be out in early 2026. We had a 2014 report that was out about victims' compensation. And then 2 years ago, we released our victims' agenda. And so all of that can be found on our website. We're also going through a brand refresh. So in the next month or so, you'll see a bunch of new data on our website as well. But yes, all that can be found on our Alliance for Safety and Justice website.
Does anybody else have questions for Tanish? All right, before you go, Tanish, I do have one question, which is, I don't know if you saw the DA or heard the DA's suggestion about having Marcy's rights being read or at sentencing or plea agreements to make sure that DAs reach out to the victims. Is this something you think is, I don't want to put you on the spot if you haven't thought much about it, but do you have an immediate reaction to that?
I think making sure that victims are aware of their rights is always a good thing. You know, I understand the challenges that might be presented in terms of like delaying proceedings, and proceedings are already delayed, so we don't need more of that. But I also think about, you know, beyond in the court proceedings, how many cases, how many folks are already not being informed about their rights as victims, and just seeing how much of a need it is. So I do think that it's important to consider.
Thanks. All right. Again, any last questions? Tanish, always good to see you. Have a good
Thank you.
weekend.
Thanks for asking.
You're welcome.
Right.